he was holding the camera in their face. Then, thereafter, went and posted it on YouTube.
But you said there's a male unknown just recording everything and won't leave.
Okay. We do have officers on the way. They will be there shortly. Does he have any weapons I know he has a camera, but other than that, any weapons at all?
He was recording this city council meeting to thereafter post it on YouTube to get likes and subscribers and make money off of his YouTube channel. He was recording this city council meeting the entire time so he could post it on YouTube and get a reaction out of his subscribers. He actually has a lot of subscribers.
Clearwater's council doesn't like me recording their meetings and sharing them online because they think it's for clicks and views. They prosecuted me after I spoke out when they kicked out a man for a shirt that said fuck, and they cut their live streams to hide their misconduct. Now that I'm banned from attending the meetings for 6 months, I'll be uploading all of their meeting videos to my channel, not for clicks and views, but because the public has a right to. And I know it will aggravate them, especially if they think I might make ad revenue doing it. In Florida, the state's constitution and laws prohibit claiming copyright on public records created by public entities, public records, including meeting videos. To prove that I don't have to go to their meetings to record it just to get clicks and views, I took their video and uploaded it to my channel. This is a side-by-side view. This is the city of Clearwater's version. They've gotten 238 views in 6 days. This is my version that I uploaded. It's gotten over 2,400 views in just 5 days. They've only received 3 likes. I've received 114 likes. They haven't gotten any comments because they're so afraid of dissent that they don't allow comments on their comment section. I've gotten 39 comments on this video.
How we doing?
Okay.
Good.
You're in thinking.
We're reading. I was. Today's meeting of the Code Enforcement Board is called to order on Wednesday, August 27th, 2025. Welcome, everyone. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Agendas of today's meeting are on the wall at the entrance to chambers. Please remember to turn off your cell phones. It is this board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board considers new business items in 2 parts. First, the violation, and then affirmative relief. Formal rules of evidence do not apply. Each side is limited to 15 minutes. The board may grant additional time. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from the chambers. Now I ask all who plan to speak to rise and be sworn in by our clerk.
Do you swear or affirm to tell the truth throughout your entire testimony?
I do.
Thank you.
Our first order of business is to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
There were some people that didn't.
They don't have.
They didn't understand.
If you plan to
stand.
speak, please stand. Are you going to speak in this meeting today? Everyone that plans is going to speak, please stand and be sworn in by our clerk.
Do you swear or affirm to tell the truth throughout your entire testimony? Thank you.
All right, our first order of business is going to be to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
I so move.
Yeah.
I'll second it.
All in favor?
Aye.
All opposed? Minutes are approved. Is there anyone here to speak on items that are not on our agenda today? No? All right, we will get started with our new business items, which is 4.1 on our agenda, case 71-25. Find respondents Ann S. Collins Estates at 1877 Springtime Avenue in violation of code for roof maintenance, door and window openings, and exterior surfaces, and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? No? Inspector Dixon, you have the floor.
Good afternoon, Board. Inspector Gregory Dixon, Co-Compliance Office, City of Clearwater. This is case 7125 for 1877 Springtime Avenue. There are 3 violations at the property for roof maintenance, door and window maintenance, and exterior surfaces. Notice of violations started going out in April, and the mail came back, so it was reposted with a compliance date in July. This is the property, there's a tarp on the roof, and all or most of the windows are boarded up. Here's the day I posted the property along with a bunch of some nuisance cases along with these three. Here's the property in June. And I believe this is today. I think the picture is a little cut off, but the front yard's been cut. That's the only change to the property.
So there is somebody possibly living there?
Yeah, I've seen people come and go. They don't talk to me, but the grass got cut in the front anyways.
Pretty dark in there.
Yeah. And hot. Compliance can be met for the roof by maintaining the roof in a clean, mildew-free condition and kept free of trash, loose shingles, debris, and other elements, including grass, weeds, and tarps, as well as anything that's not a permanent part of the building or a functional element of its mechanical or electrical system. Compliance can be met for the doors and windows by removing all boards and coverings from all doors and windows. Ensure all doors and windows are in good repair, including the window frames, sills, and panes. Compliance can be met for the exterior surfaces by replacing any defective structural or decorative elements of any building wall, and ensure all exterior surfaces are free of mildew, rust, loose material, and faded and peeling paint. Case 7125, 1877 Springtime Avenue for the three violations, requesting compliance on and before October 1st, or a fine of $150 per day per violation if compliance is not met.
All right. Board, do we have any questions for Mr. Dixon on this case?
I move to find a respondent in violation of the code as referred to in the affidavit in this case.
Second. All in favor?
Aye.
All opposed? Motion carries.
I move to enter an order requiring the respondent to correct the violations on or before October 1st, 2025. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
On the second?
Second.
All in favor?
Aye.
All opposed? Motion carries. All right, next on our agenda is 4.2, case 72-25, find respondents Carolyn Gravely Moss at 1811 North Fort Harrison Avenue in violation of code for exterior surfaces, and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? No? Inspector Dixon, you have the floor.
This property's come into compliance. We'd just like to request a declaration of violation.
Okay. Can I get a declaration, board?
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation is corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may enter forward fine up to $500 for each day each violation continues to exist.
Second. All in favor?
Aye.
All opposed? Motion carries. All right, next is 4.3 on our agenda, case number 73-25, find respondents Rash Holdings LLC at 692 Bayway Boulevard, number 405, in violation of code for short-term rental, and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? Will you come forward, please?
So that's this.
Come on up.
This is big.
Are you represent the property owner? You're the property owner, okay.
Will you step to the podium, please, and state your name and address for the record?
Okay. My name is Melanie McNamara. I'm the sole owner of Rash Holdings, LLC.
At your address?
My home address or the property address, either one. In Clearwater Beach.
Okay. Do you admit or deny the violation today?
I deny it.
You deny it? All right. If you'll have a seat right there, we will get back to you and hear from the city. Thank you.
Thank you, Mr. Chair. Jared Simpson, I'm the attorney for the code enforcement staff, and I thought it would be helpful if I just came down here because this case is a little bit unusual from what you're used to seeing. So I'll try to walk you through it, and of course, if you have any questions, feel free to ask. The first thing I wanted to show you, I put on the overhead, this is the notice of violation that went out. Just want to clarify what the city is alleging here, and it's section 1-104, and it says essentially that you can't use a building unless it's in conformity with all development approvals. So what makes this case a little bit unusual is that the property is located in the tourist district, but the development order that approved the building that's built there was approved for residential use. So short-term rental, it's been longstanding position of the city that short-term rentals are not allowed in this building, consistent with that that development order, and I'll get into that in a little bit more detail. So in the notice of violation, we do cite to the development order, and that was approved for single-family use as an attached dwelling. It was not approved for a resort attached dwelling, which I'll explain is a different kind of use. There's never been a change of use application that was correctly processed and approved. And so they haven't gone through that change of use to migrate from attached dwelling to the resort attached dwelling, which would allow for short-term rental use if that was the approved use, but it's not. So the other thing I just wanted to point out, what we cited to, was that the owner, which would be the previous owner to who's being cited now, this was the developer at the time this was developed, specifically stated in their application that that the basis of why they were changing and redeveloping the property at the time was to change from overnight accommodations, which was what was there before, to the attached dwelling residential use. So we highlighted in the notice just to make it further clear. We don't know what all information they have on the history of the property that they've bought into, so we're trying to give that to them in the notice. But you can see here that in the application, they specifically assured the city that the replacement of the overnight accommodation use with an owner-occupied use would help reduce the transient tenants in the area. So that was their assurance as an applicant at the time to the city. And in exchange for that, they received this development order that was approved, and I highlight the date for you, in 2003. And according to this development order, the attached dwellings were approved. And you can see from that list there, a whole host of regulations were given flexibility based on that assurance. So all of these setbacks, all of the setbacks were reduced. The height restriction for that property was reduced. There were some building separation issues. There's a dock that's associated with the condo. There was some concern about that being a commercial, could be converted into a commercial dock if this was a hotel. All of those things were sorted out, and as part of that approval, so the city approved the reduction of setbacks and height, all of those things, and they imposed several conditions. And amongst the conditions is that the, sorry, I didn't highlight this section, but I'll point to you for you, that the dock itself would be for the exclusive use by the residents or their guests. And so this, just to kind of give you the history of what was approved here, was that they had requested for the residential use, and that was what was approved back in 2003. Again, I've got here another related document to that. This is the staff report that was submitted. According to the staff report, they were changing from overnight accommodations, which is what they had before, to the attached townhome dwellings. This I actually didn't include in the packet for you, but I'll just highlight it for you on as part of the record. But the application itself talks about, it makes several references throughout their application about access for the homeowners, the fact that there were not a lot of high-end residential uses, and that was part of the reason why this would be good for this part of the beach. All of this I'm explaining to emphasize the point that they made, the developer at the time made all of these assurances based on a residential use in order to get those setback reductions and other benefits to be able to develop in the way that they wanted to develop at the time. The next thing, I'll just highlight a couple of code sections for you to see. I actually realized later that this is actually a level 2. I believe it was a level 2. Regardless if it was level 1 or level 2, there's code section for each one, and it specifically says that approval authorizes only the particular use approved. So, this type of use is allowed in the tourist district. Let's be clear that the short-term rental use would be allowed if it was a resort attached dwelling. It's not a resort attached dwelling. It's an attached dwelling that was already approved, and that particular use is what was approved. If they want to change the use, they have to go through the change of use process. And that's what this code requires here. And then just to show you again that our code has different definitions for these different types of uses. That's to explain that these are different kinds of uses. And what is the key distinction between them? It's for a resort attached dwelling, it can be offered and advertised for any term. So what that is intended to say is that if you're a resort dwelling, you can have short-term rental there. If you're not, then you can't. And so that's basically what these definitions say. I will point out this too, just in acknowledgement, because there has been some confusion on these issues. That's why I'm here trying to help explain and bring clarity to the situation. The city has sent notices out that included this reference to this code section, and that has caused some confusion because this specifies the residential zoning district, and that's not where we are. We're in the tourist district. So we're trying to clarify that now. I've gotten involved and we're trying to clarify that technically this does not specifically apply, but this section does not prohibit anything. What this section does is it creates an assumption or a presumption. It says that if any of these things are occurring, then you as the code board should go ahead and presume that this is a short-term rental in a residential zone. So these are the factors that we consider in determining whether or not something is a residential use or not. And because there's a heightened concern about short-term rental in residential zones, we create a presumption in those areas. So it's sort of like a heightened presumption, a heightened evidentiary burden for those areas. But that doesn't mean that it doesn't apply at all. It's just sort of a presumption that only applies in that zone. But it's 30 days. And then just to clarify where 30 days comes from, that comes from state law. And when you look at what the state law, how the state law defines what a public lodging establishment is, essentially a hotel or a transient lodging establishment defined by state law, is something that's rented for less than 30 days. So that's where the city gets that's where we get our position that if you rent for anything less than 30 days, it's no longer a residential use anymore. Now for this particular, that's sort of just I'm trying to give you kind of the legal background in the terms of the specifics for this particular violation. We had a complainant who was also a witness. She's the one who's been requesting that the city take action on this. We asked her to sign an affidavit, a sworn affidavit, to authenticate some of the documents that she was sending to the city. I also specifically requested that she appear today in case there were questions from the board of her. I don't know if she's here or not, but if she's not here, then we may ask for a continuance on the matter. But I would like to hear from the property owner in light of all of this.
Someone's waiting.
Okay, all right. So since she is here, we would ask that she be allowed to speak as part of the city's presentation before we turn it over to the property owner.
Would you come forward, please?
And Rebecca has more on the facts regarding this particular violation.
Thank you, Jared. Good morning, Board. Rebecca Mulder, Code Compliance Manager with the City of Clearwater. Nice to see you all. So today I'm going to be presenting the case that Jared has been building up to. So it's 692 Bayway Boulevard, Unit 405. It's for Code Section 1-104 for our jurisdiction application related to the development and use of the property related to the short-term rental use of this particular unit within the tourist district in a resort property or a non-resort property. Notice of violation was sent and posted, went out on 6/26 and posted on 7/15, receiving the certified mail back on the 17th as well. As Jared mentioned, this was not something that usually when we present a case to you for a short-term rental violation, there are Airbnb or VRBO listings that are associated that we show you those documentations. We didn't have any of those as verification. We received multiple complaints from one of the occupants within the property at Bayway Boulevard stating that this was happening even though there wasn't evidence that we could identify through our traditional means. She provided what you see up here from one of what she states is one of the visitors of the unit, they showed her that she was there from May 9th to the 18th and provided that to us through her sworn affidavit. This is just a visual of the affidavit that we sent her. She did testify to that document and her observing that personally. And we can ask her to come up and provide any more details. We just don't personally, within the department, have more than her sworn testimony. So we're bringing that before you for you guys to determine if you deem this a violation based on the information that Jared and I and the different testimonies within the complainant and the property owner. If you do find them in violation, then we will be requesting a fine of $150 per day per violation for a one-time fee of $13.50 resulting from that 9-day stay rather than a continuous accruing fine because, like you said, we are not seeing those listings. We just have the one documented stay that was presented to us. So we'd just be looking for a one-time fee.
Thank you.
Do you have any questions for me before I turn it over to? No? Okay.
Can you state your name and address for the record, please?
Penny LeGrand Crawl, Clearwater Beach, Florida, 33767.
Welcome. What would you like to tell us about today?
This has been ongoing for many years. The developer did not ever file paperwork, so it reverted to, from the very beginning, to a 30-day minimum per the state and the city codes. Around 2017, there was an uproar among owners wanting to go to 7 days. The city said, sure, you can do that. 100% had to vote for that. It has been voted on multiple times and has not been 100% and continues to get less and less. Folks are still doing this. You guys have fined them before. They were told to cease and desist. This happened again this past fall. They were supposed to stop by the end of December. You had given them sufficient time, approximately 2 months. That did not stop. It has continued, and it has continued. And the saddest part is several of these folks are HOA board members. We have had attorneys tell us we are not a RAD. And so with that, I think this needs to continue to be enforced. These people need to be fined And it needs to stop because the residents there are becoming the victims of these people in and out.
And you've witnessed this yourself, the different people at
Yes,
the
I
location?
mean, there are several of us that live there full-time. People come in. I don't speak to them until they speak to me. Then they openly say, you know, what's good to go eat, what's good to do. And then they say, oh, well, we need to do it quick. We're only here for X amount of days.
Board, do you have any questions for Ms. Crowe? Thank you for your
Thank you very much.
Thank you.
Yes, please.
If I may, could you just speak to the review document that you provided that Rebecca presented to the board?
From the 9-day?
Yes.
They were a very nice family, I believe 5, from Upper New York. They were at the pool every day. I walked past them. They would, say hello, and then they started asking different things. And like I said, they said, they were only here 9 days. And then I said, may I ask a favor of you? I said, this will not get you into trouble. I said, but they have found a way around this, and I don't know where they are getting their postings. And she said, oh, here's mine. I said, would you mind sending me that? And she said, sure, but can I wait till I leave? She said, because I don't want to be thrown out on the street. And I said, absolutely. So they left. 2 days later, when she got back to New York, she sent it to me. And I was grateful for that because the burden has been put on us residents, and it has to stop. And until you guys can hit them in their pocketbook, it's not going to stop. And the other thing, I know there's tons of legal ramifications because the short-term rental has a lot of lobbyists, but they need to be held accountable too because iTrip is posting it everywhere, and the local person is Kevin. So he is just as much at fault as the homeowner.
Can you also tell the board how long you've lived in the property?
I moved there in October of 20, but did not purchase it until January of 21 because of roof issues. I could not get a loan.
Can you explain more about the association? You had mentioned something earlier about there being some votes. What is the most recent conversation that the association has had regarding this issue?
I know that it was either last year or the year before the HOA board went back to the attorney for the association and spoke with them about this. And then they were, I'm not sure exactly how it all went. Then my husband contacted the city. The man explained to us that the developer never filed 7 days or less. It was always 30 days, has been, and again, the issue came up again in 17, and they were all sent notices that it was not allowed. It was a 30-day, and that, again, it had to be 100% to vote to change it and to pay the fee. That's not ever happened. I think the last count is 4 or 5 people will not, and I will never. So they'll never get 100%. They need to quit spending the HOA money on attorneys and be held accountable to what they purchased it. And this resident did purchase this knowing it was 30 days.
Do you know if the association has hired an attorney? Are you aware of who the attorney may be?
I know the HOA board has, an association has an attorney. I don't know who that is. I think it is with a firm and then it's placed in different folks' hands. But I don't know who that is because they're not there to, at this point, to protect me and the other residents who do not want this.
Okay, so are you saying that as far as you know, the association does not have a formal position on this, or do they?
I can't answer that.
All right, I don't have any further questions.
Thank you. Thank you both.
I have a question.
Yes.
You said that you know that the owner doing this knew it was a 30-day rule. Just out of curiosity, how do you know that?
Because her son, and her realtor sit down at the pool with my husband and a couple other residents, I believe twice before she purchased, asking about the property and different things. And she was told very clearly that it was a 30-day. There had been issues, but it was 30 days.
Thank you.
Any other questions from Ms. Kroll? Thank you.
Thank you for your time.
May I just one?
Yeah, I've got a couple of questions I'd like to ask you.
I just wanted to make kind of one comment before we pass it over to the property owner and hear their case. But for clarification, the change of use, that application and that process, it would not come to the code board. We're asking for them to do that, and if that were approved through that process, then that is one way that this could come into compliance and short-term rental would be allowed. We're indifferent on that because the code, it either allows it or it doesn't. That's their situation to figure out amongst the association. What we're here today to say is that that's not the use that is currently approved. And so if they want to go through that change of use process, they can do that. That's one way to get to compliance, or they can stop short-term renting. That it's either one. But I did want to clarify that because I'm sure that there will be questions about that process and what it requires and what it would mean. We're not really prepared to get into all that today, and it's really not. This really isn't the forum for that. Okay.
Thank you.
The only question I had for you, Jared, is there are other units in this place that are approved for transient. Do you, to your knowledge, is that?
It's our position that the property, as a whole, containing all the units, is approved only for attached dwellings. And some of the history regarding the change of use, there's been some discussion about whether or not a single unit could apply for and become allowed transient in a single unit. Our position is that really doesn't work because the community development code requirements apply to the entire property. The parking numbers may be impacted, the setbacks, the different rules apply to the entire property and impact everyone. And so because everybody has an interest in all these common elements, everybody needs to be involved in that process. That's our position.
That's kind of where I was going, trying to get the answer for was what you just said. Okay. All right.
Thank you again.
Board, do you have any questions for Jared?
No, I think he answered them.
Do you want to come back up, William? So can you tell us why you don't think that you're in violation when your developer had a lot of stipulations for the development of it and
Okay. It was built in 2002. That's when it first came. Developers marketed, sold, and used as short-term rentals 7+ days. Land use designated resort facilities high in development orders, and it's on pages 38, 39, 40. Resort attached did not even exist until 2009. There are 3 additional listings that I put in the book that you guys can look at from the original listings. They all say 7-day rental. Complete copy of our bylaws state 7-day rental. It's on page 20 of our bylaws. In Florida, cities generally cannot restrict duration or frequency of short-term rentals, as this is the power reserved from the state. And there's a copy of a document which is given to potential buyers before you buy that says if you do not agree with the bylaws, then don't close. You can get your money back. You can void the contract. Everyone in this building bought. everybody. There's copies of the code concern that I think is very important, because when this rental occurred, let me just get that real quickly. Okay. I'm sorry I have to do this because it's bad.
I'm sorry to interrupt you, but wouldn't the people who bought want to go back after the developer for them saying that, them not filling out the paperwork for them to have a...
That predates, I bought in the end of '23, and the bylaws have never changed, and they probably will not change, because that would be up to the owners.
Have you guys got any sort of grandfather clause that says your building is grandfathered in to not have to?
I have things from the code people that it says this property is within the tourist, these are poorly, the ink is very light. Therefore, a monthly rental is, oh, okay, thank you. I don't know if you can see any better, but it says, this is from Sarah Green, this property is within the tourist zone of the city, therefore monthly rental is not applicable. So they're not going to enforce it. And that was when my tenants booked, and we had several bookings during that time when all this came through. And then a resident wrote a letter to Mrs. Jennifer Poirier, and then they rescinded that. So we're wondering where we stand.
So they rescinded this letter?
They rescinded it, but we had bookings. And I agreed to accept the bookings that I had, and there was one booking that this violation involved. And they booked it in November when this was all in conflict, and they put a deposit down, ready to go. It wasn't my fault that the city gave us permission to do it and then rescinded that order. I'd like to know why, when the city gave them the order that we could, this building could all be developed, and then everything changed, because it was used as it was designated as a high use. It was designated in the tourist section, and it was marketed, sold, and used that way for several years until I think it was 2000 and whatever Penny said. But it wasn't, the city council didn't do the resort attached until 2009. So we were already up and running. This condo was running as a short-term rental. We all bought it. It was marketed even in '23. It still said 7-day rental. So I don't believe what Penny would say to me when she says that we were told when we talked at the pool, because I had paperwork that conflicts that. So paperwork to me is more important than hearsay. I can't bring hearsay into this courtroom, but I can bring proof. And I'm bringing proof that we have 7-day rental in our docks. And we have 7-day that was used up until they got the cease and desist. I think it was in 2012 or 14. I don't remember that. That predates me as well. But I bought this unit based on how it was marketed, the bylaws, and I feel I have the right to do what our bylaws state. But I do appreciate you all inviting me here, because I think there is a lot of confusion. And the very fact that they had an attorney come to show all this confusion.
He normally sits right there. He's just out there in the audience today for this.
Oh.
He's our attorney now.
Oh, okay.
We're flanked by him on each side.
Okay, well,
So,
I'm not an attorney, but I do research.
I think this problem, if I'm correct, it all stems from the developer not filing the correct paperwork back when he...
I've got questions.
Yes, go ahead.
Me?
of Jared.
Okay.
Thank you. So I'm trying to wrap my head around this because there's a lot of pieces of data floating out here, and I'm trying to figure out what's what. From what I understand, number one, we've established it's in the tourist district. And in the tourist district, they normally allow 7-day rentals. However, on this particular property, there was an application or a petition or whatever that requested the change of use of this property, which at one point was allowed for tourist 7-day rentals, but there was something that was filed, requested, and approved to change it to a different use. Am I correct so far?
Can I clarify?
Yes.
So in prior to 2002, there was a 24-unit hotel on the property.
Okay.
And the use that was approved at that time was called overnight accommodations. The developer bought the property, they wanted to build the condos that are there now. As part of that application, they needed to get setbacks reduced, they needed to get some other rules, some flexibility with those. They applied for a residential condominium as part of the assurance or inducement to get the regulatory board, the CDB of the city, our community development board, to approve that development with lesser setback rules.
Right.
And so they were saying this will be a residential condo, that's why you should grant the setback reductions. So they got a development order approval in 2002, I believe.
Built in 2002.
You have that date in front of you somewhere.
Yeah, it says built in 2002.
I believe you said the building was built in 2003.
Well,
that
I
would
think
make
the
sense.
paperwork
So-
is 2002.
Right, so they got the approval for residential dwellings in 2002. Now, she's correct that the definition for tourist dwelling was not adopted till 2009, but it was really just a clarification that there's a difference between a residential dwelling
There's always been a
and
difference.
something.
Yeah.
There was always a difference.
They just reworded
Previously,
it.
it was overnight accommodation.
Okay, they just changed that overnight accommodations to.
That's our position on it. They
just changed the wording, not the.
It was a clarification in the definitions that this is a different type of use. And so the condo declaration, which is what she's also referring to, the 7-day rule, that's their private association documents. The city, we don't enforce private association documents. Sometimes, most often, the private declaration is more strict than the city rules, and so the association has a heightened level of regulation. That's the most common scenario, but here it's different. Here, the city, because the development order specifically approves residential use, the city's rule is actually more strict than the declaration. That's our position as well on that. And then the last point to just quickly address, they were mistakenly told that this was allowed. That's just an unfortunate mistake that we have to acknowledge and say that it happens. This is why I'm here, to try to help explain all of this. It is admittedly more complicated than the normal case, but that's why I'm here trying to help explain, and this is our position on it. So, there's obviously they have a different position.
So you're also saying that when you say the private declaration, that's the same thing as the bylaws, basically?
Well, I think those are two different documents. I'm
Okay.
assuming that she's referring to the declaration when she says the bylaws, but I'm not, because I didn't see exactly what she was talking about. I'm assuming those are two different legally operative documents. They're not really relevant in our view.
Right.
Because the city we don't enforce those.
Right.
If they wanted to change their bylaws and their declaration, they can. Well, all we're saying is go through our change of use process to allow for this change. And then, who applies for that, how many people need to sign the application, all those sorts of logistical questions about that process is sorted out in a different way through the city. That goes through the CDB, the planning department handles those applications. It hasn't happened. So we've been asking for it, it's my understanding. I think some of the staff can speak to the factual details of that. my understanding is that we've been asking for them to go through that process, sort it out amongst the association, come up with whatever their group solution is, come in, apply. If the staff denies it, there's an appeal for that to the CDB, where the members of the association can come, they can speak to the CDB, they can tell their case there on whether the use should be changed or not. It's a separate process. All we're saying here now is that that never happened, it hasn't happened, and until it happens, there's no short-term rental allowed.
From what I understand from the president of the association, there has been 2 attempts to try to go through that program, and we never get it up to a next level. So it's been very frustrating.
So you're not necessarily grandfathered in, they just changed a word. And the rules still apply, they just changed a word to, I guess, to whatever the
approved use.
The approved use, you know, it wasn't that.
We were an attached dwelling, I think that's what it was stated, and then it became a resort attached dwelling in 2009. And we think we should have been grandfathered into this because we were already being used as a short-term rental. It was marketed, sold, used until that time. And then in 12 is when they, I think, got cease and desist orders on their doors, and here we are.
You said that occurred in 2012?
I think when they got their cease and desist, it was 2012, but the resort attached happened in 2009. And I think most of the current board members were not there at that time. I'm a board member, and I would like to get this resolved that we can rent, because that's how it was sold.
Right.
And it's very frustrating. And I'm a widow that my husband died in 2022, and I bought this place, and I thought this would be a great place for my kids to come. And I could also use it for income. So my income's been depleted because of all these rules. I can't rent until it's like 30 days now. And, you know, I also think that the property is being depreciated because, you know, there's the police station and there's the building next to us that is renting 3 days, you know. So it's like, we would like to be able to rent as our docs say. Pardon?
I said they haven't come, that property hasn't come before us yet. But now that we're aware of it, I'm sure our inspectors might go out.
Well, it's advertised.
And they may be
for
coded
3
for it.
days.
They may be approved.
And I think that's the only one on the island.
And they might be approved for that, too.
Yeah.
You
And
never
it's the
know.
only one on the island from what they've, advertised it as.
Yeah, in
That's
that
the
area.
question here, is that you guys just didn't get the approval for the building. You know, regardless of how it was marketed or sold to you. I mean, you know, I can say that my
Well, it said it was.
car is in perfect condition. And,
Yeah, but I just want to make a comment.
I won't buy a car from you.
Being a real estate broker, I know that when a buyer goes to buy a condo, they depend on what's provided by the condo.
Yes.
And the docs clearly say, no lease shall be valid or approved for a term less than 1 week. Right here. And then I just want to make another comment, because you can't always trust what the realtors say. Being a realtor, I know this,
Okay.
but I just
They can't
noticed
supersede.
that there were 2 listings in 2004 and 2005, same realtor, all 3 listings. She says 1 to 7 days, but then in the listing in 2018, she says minimum lease period 1 week. So she even changed what she was saying
Right,
from the
because it only
beginning.
said 7 days.
Yeah,
But
but
does this couldn't supersede what the city's ordinance?
I understand, but when a buyer-
what they're being told.
what a buyer reviews
Yeah.
are the condo
Yeah.
docs. They don't necessarily go,
Yeah.
okay, to the city, is this true?
Yeah.
Because this is what the condo provided.
And it's the original documents.
Yeah, I just wanted to make that comment.
Thank you.
You're welcome. But that that it's against city code is a different situation, and that's what we're talking about here, not hitting this.
Well, I would like the board to take a look at everything that's provided there, because I think it is a history, and we need to take care of that history.
That's a lot for us to look at in a short period of time.
The
that we're
page is
here.
tabbed. If you hear, want me to find it for you?
What are the dates of the letter that you had that was rescinded, and what was the date of the recension date, or letter?
I'm sorry, I don't understand your question.
It's right here in this package.
Okay, could somebody
Okay.
Here,
look at that?
yeah. page. See
Well,
those?
just the dates on this.
Okay.
Give this so that I don't think
There is, it is.
I know you're still back there, I'm not.
I'll give you those two when we come back.
I don't need to see it.
All right. Any other questions?
Do we have any other questions for her? I mean, I'm kind of stumped right now.
Well,
What were the
there's
dates of
city-
the rental?
What's that?
What were the dates of the rental?
It was 9
May-
days.
May
Yeah.
9th through May 18th, I believe.
This year?
Yep, of this year.
So based on the rules, it was in violation. Now it's a matter of deciding how they got to that point of being in violation.
Chair, do you want to, if there's no more questions, we can ask them to sit down so you can...
Yeah, if you want to go ahead and sit down.
Yeah, go ahead.
Thank you.
Thank you. Ms. Kroll, did you want to come back up and say something?
see the original
Real
letter.
quick, or present
This is the
something?
extension. And that was November 12th of '24.
This is from the
Go ahead
city.
and stick it on that thing there so we can see it.
So that was 6 months.
Yeah, before that.
6 months before the rental, it was rescinded. The earlier letter was clarified and rescinded.
But it only went to these people. It didn't necessarily go to everyone in the building.
Can't hear you
don't
guys.
know. That goes in the back of the red folder.
Go ahead, ma'am, what's this?
This is from the city saying how it can be changed. Since, yes, our HOA docs say 7 days, but the city overrides that. After that, the state overrides the city, and after that, the federal overrides that. I understand that from a legal perspective. 7 days doesn't mean anything. I bought in '21. We knew this issue. It was brought to us by our, realtor. My husband called prior to closing, and they said, yes, it is 30 days.
But in your packet that you got from your realtor, like this one, it said 7 days?
The HOA docs say 7 days. The realtor was very clear. They had went through all this rigmarole because of the developers saying it was 7 and it was not. And I understand that. I don't think there's one person left in.
Your husband called the city, yes, though,
Yes,
to
he did.
check?
To check.
Well,
And we
she
have
did.
verified that again a year later when it all starts unraveling again. Again, it takes all 15 owners to vote. It has been voted on. I think this is the last time, was in '22, August of '22. It did not pass. Again, it's only as good as the paper it's written on. The HOA docs may never change, but it's still not 7 days. The city says it is 30 days, 100% resident vote, $400 application fee. Not going to happen in my lifetime. We've had other residents that got on and had their own attorney verify that we are not a RAD.
Rad?
Resort attached dwelling.
Thank you. Okay. So this email we're looking at here, this is, did you leave that on the screen?
Your microphone.
This is,
Sorry, your microphone is there. I was looking at the wrong microphone. Your microphone is
Okay.
there.
This is from who to who?
This is to my husband from the city of Clearwater.
Okay. So it sent you, it wasn't necessarily something the
And it told how, if our community came together and wanted to change it, what had to be done.
Okay,
It's not going to pass.
I got you.
They will never get 100%.
Got it. Okay.
All right, Board, do we have any more questions for Ms. Kroll?
I'm trying to write a motion.
thank you.
Thank you.
All right, board, I'm kind of stuck. I mean, if anyone else has got any clarity on this.
Well, it is the violation.
Well, I understand.
Exactly. It's that, it's that clear, really.
Now, you can.
Mr. Chair,
Yes.
may I make a comment? So just in closing on this matter, we're asking that there be a finding of a violation. You've heard evidence that a booking occurred. I don't think that they object to that. It sounds like they're just objecting to the rule, the application of the rule. You've heard our explanation of what the rule is, how it applies, the declaration, the private restrictions between the association and those private documents are separate than the city rules. Hopefully I've explained that adequately for you. We're just asking that you find that there be a violation. If you want to go ahead and make a motion to that effect, maybe there could be more deliberation on the fine amount. We have suggested a fine amount based on the fact that we know the booking had already occurred. We're not aware that they're advertising still. It's our position that it's not allowed until the use is formally changed through the process. And they, whether that passes or who needs to apply, all that separate process. Yeah. But we're just asking for a finding of the violation based on the past booking. If you want to make a motion to that, then you can deliberate on whether or not the suggested fine amount is appropriate. But we made that suggestion in light of the fact that it should have some deterrent effect on the future if you agree with us that this is in fact activity that's prohibited unless and until it's changed.
I have a question. Were all of the owners notified of the city's standing?
There have been conversations. Obviously, there's actually been some litigation with the city. I haven't mentioned it because I don't think it necessarily has relevance to this particular proceeding. But we're doing the best that we can to clarify our position on everything to as many of the residents. I've requested staff to notify folks of this. We have adjusted the way that the notices read. In the past, as I explained earlier, we were referencing a residential zoning district, and that's because those notices were automated by a software that we use. So because this got a little bit unusual, I assisted the staff to try to clarify the city's explanation of all this in our notices. So we've tailored our notices a little bit better to try to explain in the future. Other than that, we're just going through our normal code enforcement procedures with this.
I mean, basically what we're here to do today, I mean, what only the board can do is determine whether between May 9th and May 18th, they were in violation of the 30,
That's right.
nothing less than 30 days.
The city, right, codes.
Are we closing public public questions so we can move forward to the board?
Ms. Mulder, would you like to wrap up something?
I think Jared summed up our request from the board well. We're just looking for a determination based on the evidence that was provided to us within the department from the property owner, one of the other property owners of the violation.
Ma'am, you come back up and say your closing statements. But basically what we're here, the power of our board is only going to be to determine whether you were in violation between May 9th. However you got there, that's not for us to decide. But between May 9th and May 18th, you were in violation of the city's short-term rental code. And that's what we're here to determine. And we have determined that you were. Even by your own admission.
We haven't made any determination.
We haven't made a motion.
We haven't determined that yet.
I think there's been so much
the evidence that has been
confliction
provided
here.
shows that you were in violation between May 9th and May 18th.
Well, even the city employee said that we could do it, and then all of a sudden someone else, after a letter was written, said we couldn't. I was not provided all that until the very end. So I think when we honor something that the city said we could do, that's on the city. I don't think it should be on me. I don't.
Wait, hold on. This needs to stop at some point. You've heard all the arguments.
Yeah.
You know, this has to come back to the board for deliberation. No disrespect, but this is, you've heard all the evidence that's here. Now you're hearing just interpretation and argument as to the evidence. It's for this board to decide.
Okay. All right, thank you, ma'am.
No, but it's
Mr. Chairman?
Yes.
I would suggest we do the first section of this and then see if there's any further discussion on it. Assessment.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second?
Second.
All in favor?
Aye.
All opposed? Motion approved.
No.
That's what now.
My comment is that there seems to be a lot of confusion and lack of understanding, and there's a lot of documentation involved. I can understand what the city's position is. I can also understand what the property owner's position is. And I think that based on clarifications that have occurred from the city and what their bylaws say, and et cetera, that I just understand their position. And so with that, my question is what would an appropriate fine, if any, would be?
I have the recommendation that any fine should be waived because of the confusion, and that they need to cease and desist any type of short-term rentals, and then we just go forward.
Is that a motion that can be made, Andy?
Yes. You don't have to institute a fine.
Well, do we waive it, or do we just put no fine?
I would put no fine.
So I'll make a motion that...
Hang on a second. What about subsequent violations? Do we want to keep that language in there?
That's already, that's by law, that's in effect based on your first motion. If there's a repeat, then it goes up to the repeat section of the statute.
Okay.
Does the motion have to be everything in there?
No, you can just say,
So I think there'd be, the motion that there be no fine issued and that they need to cease and desist any type of short-term rentals.
I'll second that.
All right, can you say that again a little bit louder so
Sorry, I was having trouble with my voice.
so the audience can hear you?
I make a motion that there is no fine issued in this case and that the condo needs to cease and desist any short-term rentals going forward.
Second.
All in favor?
Aye.
All opposed? All right, motion carries. You understand our decisions? Thank you. Okay, moving on to 4.4 on our agenda, case number 74-25, fine respondents Trunfan at 1408 Rogers Street in violation for short-term rental and residential business tax receipt, and issue an order with the compliance deadline, and if compliance is not met. Is there anyone here to speak on this? Will you please come forward? State your name and address for the record, please.
Trung Phan, Clearwater.
Could you spell your name for me?
Trungphan.
Thank you.
Mr. Phan, do you admit or deny the violation?
We already talked to you that we already got that handled with the person that rent our property, and it's taken care of, so he will talk to us.
But for the violation, do you admit it or do you?
We don't know what happened. So,
you don't know whether you admit or you deny the violation?
Should I say?
I'm just asking a question. Do you admit to the violation or you deny the violation? There was no violation, or was there violation?
You can have the violation and then fix it. That's
yeah. It's not like
please no contest. Is that what you said?
No contest.
No contest is a plea where you're not denying the evidence. So if you want to do that as an admission, I'd rather take it as a declaration of denial, and let's just move forward.
Yeah.
Because I don't want there to be confusion.
Okay.
This case, just if it helps clarify everything, I did speak to him earlier today. What he was basically trying to say was there was another family member that was renting this out. They didn't realize it, and he took down the posting or whatnot. So as to today, technically it is in compliance. So I would just like a declaration of violation. And I've talked to him about that, what would happen if it should occur again and whatnot.
Okay.
And that's
we can
both
do
for
that.
the business tax receipt and the illegal short-term rental.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and enter the order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
All opposed? Motion carries. Thank you. Next case is 4.5 on our agenda, case 75-25, find respondents Burham Shala at 1261 Prince Street in violation of code for exterior storage and residential business tax receipt, and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? No? Inspector Stevens, you have the floor.
All right, good afternoon, board. You guys may remember this case from last time. This is going to be case number 7525 regarding 1261 Pierce Street. This property was before you guys last time for a lot clearing, and this is just a continuation of this in a way. So this property is actually a duplex. We have two violations here for code section 3-1502 G1, G2, G3 for outdoor storage prohibited. The outdoor storage prohibited of items are not intended for outdoor use, and outdoor storage of construction materials. And then the second violation is the code section 3-2302 for residential rental business tax receipt, for them not having one. The original, this case started in the beginning of May of this year, and I was working with the tenant. There was a little bit of improvement. I had sent the violations to the property owner, and they never picked up the mail, so I had to go out there and actually post the property on June the 10th with a compliance date of July the 2nd, and I did receive the certified mail back on June the 14th. This is a picture of the posting on the 10th as well as the property itself. You can see in the front there it's got two mailboxes on each side. There's a rear unit and a front unit, and the problem is really coming from the side or rear unit, which is where all the storage issues are, except for one other spot that I will show you here on the property in a moment. This property here has a boatload, as you can see, of different items that are stored outside, and it varies from everything. There's a little bit of things that can be outdoor use, such as bicycles, but then there was raw food out there. I've seen blankets, I've seen backpacks, suitcases, things of that nature, and it's very transient. It seems like it happens to come and go a lot, but it stays in this type of status here every time that I've been at the property. So that was on the 10th, and of course I think it's clogging up on me probably because of pictures here, so just bear with me a moment. Let's see if it's going to load the next one.
That was the gentleman that was here last time, tenant.
Let's try this real quick. We'll do it this way.
That might have been one with the dock, remember?
Can you guys see that by chance, the dates on it, or no?
We can trust.
I'll try to put it back up there
There
and
we
see
go.
what happens. This is on July 2nd, the compliance date. You can see there on the picture on the right, there's actually the raw food that's outside, things of that nature. Actually like yogurt containers and things. And then on the 2nd, I also happened to notice when walking back to my truck that I could see this piece of plywood that was stood up over on the other side of the property. And you can kind of see there's some items back there. I just couldn't tell what they were because I couldn't get back to it. But we'll address that here momentarily. This is on July the 14th when I was back out there doing another inspection. The 23rd. And then this was today. And you can see that same side and that piece of wood, which is laying down on the ground that I've got underlined in red there. There are Rubbermaid bins containing who knows what stacked over in that far corner of the property as well. And then over on the other side of the property where the rear unit is, still not really any change, just a different variety of items out there. So let's focus on the business tax receipt now. This was actually the beginning of the case. They did the last BTR for a residential rental that was on this property was back in 2002. The ownership had changed place back in, looks like 2024. And you can see there's not a business tax receipt there. That biz case at the top is the one that I have open for this particular case. In going through our utilities department, I was able to check and see that there is an active utilities account for 1259 Pierce. And when I drove through it a little bit more, I ended up finding an actual copy of a handwritten lease here showing that they're paying $1,700 per month plus a $250 pet deposit for that property. And then this is on, I don't know why it's cutting off the bottom of my slide there, but this is going to be, I believe, on July 2nd, showing that they still had not obtained their business tax receipt. This one should be for today's date, showing they do not have a business tax receipt. So compliance can be met for the outdoor storage by storing all the items that are not designed for outdoor use or items that would be considered construction materials in the garage, interior of the residence, or removing them from the property by the compliance date. Compliance can be met for the residential rental business tax receipt by obtaining a residential rental business tax receipt and maintaining it every year that the unit is rented. And then we are requesting compliance on or before September 27th of this year, or a fine of $150 per day for the outdoor storage violation and a fine of $50 per day for the residential rental business tax receipt for each day that those violations continue to exist.
Are these
Thank
two
you, Inspector
separate?
Stevens. Does anyone have any questions?
Are these two separate declarations?
We can do them as one, right?
You can do them as well.
Yeah.
Came as one case.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? Motion approved.
What was the date on there? September 27th. I move to enter an order requiring the respondent to correct the violations on or before September 27th, 2025. If the respondent does not comply by that date, the board may order a fine of $150 per day for each day each violation continues, per violation for each day each violation continues to exist. If the fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
What he showed there had two different amounts of fines for two different violations.
Yes.
So $150 a day on here does not address the $50 on the second violation.
Business tax.
The BTR.
On the BTR.
$150 for the outdoor storage and $50 for
Right.
the BTR.
So the motion should include those two separate amounts.
Right.
Okay.
150.
I'll redo the motion. Can I just do both amounts in it separately? Is one, like say
You
150?
can do them both at the same time, you just,
Just
150 for the one and 50
spell it out
for the
separately.
second, yeah.
I move to enter an order requiring the respondents correct the violations on or before September 27, 2025. The respondent does not comply by that date. A board may order a fine of $150 and also a fine for $50 for the BTR per day per violation for each day that each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All
Good
opposed?
clarification.
Motion approved. All right, next is 4.6 on our agenda, case 76-25. Fine respondents Lika, Redzale, and Mazemi Rev Trust at 9 Octurus Avenue in violation of code for 9 North Octurus Avenue, and issue an order with compliance and deadline to fine if compliance is not met. Is there anyone here to speak on this case? Will you come forward, please? Please state your name and address for the record, please.
Zanette Hashani, 1455 Lime Street, Clearwater, 33756.
All right, Mr. Shana, do you admit or deny the violation?
I admit it.
Admit it?
Yeah.
All right, if you'll have a seat for just a second.
And Board, this is going to be noted on these cases that we're seeking a declaration of violation. As of this morning, the property has come into compliance.
I Move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine up to $500 for each day the violation continues to exist.
Second. All in favor?
Aye.
All opposed?
Thank you.
All right, motion approved.
Thank you, Board.
All right, 4.7 and 4.8 have been withdrawn on our agenda. 4.9, case 79-25, find respondents Gilbert Janelli at 23611 U.S. Highway 19 North in violation of code for prohibited signage and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? Yep.
And we have the attachment. This is the attachment.
Sir, will you come forward, please? Will you please state your name and address for the record?
Surely, Gilbert Janelli, Avenue, Clearwater, 33756.
Mr. Janelli, do you admit or deny the violation?
I admit.
Admit. All righty.
I move to find the respondent in violation.
We
can do it now.
I'm sorry.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second. All in favor? Aye. All opposed? Motion approved. Mr. Burger.
Good afternoon, Board. Stephen Burkhardt, Sign Inspector for the City of Clearwater. This is case 79-25 for 23611 US 19. And before I start, I would ask our Assistant City Attorney to speak to that because there's an annexation agreement that has to be further explained.
Thank you.
Thank you.
Thank you. Jared Simpson, Assistant City Attorney with the Code Enforcement Team. I have a lot less to say, I promise, on this one. I just did want to point to your attention that what you'll hear from Mr. Burkhardt is that billboards are prohibited signs in the city of Clearwater. When something was already there at the time that it's prohibited, we refer to that as a non-conforming use. People use the term grandfathered in a lot. The legal term we use is non-conformity. This property was actually in the county and it was annexed, and through a voluntary annexation process. Whenever the city annexes in property from the county and the property owner does that voluntarily, the city and that property owner can kind of negotiate some of the terms of how those non-conforming structures are addressed. Either they can be eliminated immediately or they can be amortized out over a period of time. Those are all points of negotiation that the parties can discuss and negotiate and come to an agreement. So with this property, that was done. You can see here in 2022, we have an annexation agreement between the city and the property owner. This is a recorded document, so it's in the public records. If the property is sold or anything like that, it should pop up in a title search, and it runs with the land. The agreement specifically says it runs with the land. I just highlight here that this was the owner that was requesting the voluntary annexation. And then a couple of terms just to highlight for you throughout that the billboards that were on the property were determined to be non-conforming, so they were prohibited at the time of annexation by the city code, so everybody agreed they were non-conforming. The parties also agreed that code liens are appropriate remedies in the event of a breach of the agreement. And then, again, just acknowledging that billboards are prohibited in the city, so no new billboards can be constructed in the city unless a code amendment occurs, which has not occurred. Billboards are still prohibited in the city of Clearwater. Normal repair and maintenance shall be performed. So the city was basically saying you can keep it, but it has to look nice and be safe and all that during the time period that you're allowed to keep it. And then the key provision why we're here today is that the owner and the developer and the city, everyone that was party to this agreement, agreed that on January 1, 2025, the billboard would be removed. So at that point in time, the billboard became a prohibited sign. It was no longer a grandfathered, non-conforming use after that date. And this was something that the property owner agreed to with the city at the time that the property was annexed in 2022. And then I did want to say also that you'll hear from Stephen, the city's recommendation. We're requesting a fine be imposed, but I did want to highlight that the agreement does specifically acknowledge that the city could enter and remove the billboard. That was something that was discussed and agreed in this agreement. So even though we're asking for a fine today, we're notifying the board, we're notifying the property owner and everyone that we would reserve that right to go and remove the billboard if it doesn't get removed, even though the board imposes a fine. We can discuss that depending on what his position is, but I did want to highlight that so that there's not any confusion. Just because we're seeking a fine does not mean that we're waiving other rights and remedies that we may have as a city within this agreement. And then the last thing, just to clarify, this is binding on the parties and it goes to their heirs, successors, and assigns. So if they're planning to sell the property or if they've already sold it or they're in negotiation or whatever, it wouldn't matter as far as we're concerned. This agreement runs with the land and that sign is prohibited as of January of this year.
Mr. Simpson, does the city's right to, as it says here, to enter the property at any time on or after January 1st to remove the book, does that fall into our abatement?
We would probably bring it back. There may be other legal avenues that we could go to enforce that, but we wouldn't just show up and do that.
Well, no, like how we do our,
right.
With our stuff, we go to they finally make it to an abatement. Or
yes.
He's leaving it open to that for later. Yeah.
That's why I mention it, because if say the board approved of what we're requesting and then months went by and the billboard was still there, we would probably come back and at that time ask for the board to authorize an abatement.
Okay.
But I'm not committing that would be what we would do, but that is a possibility, and so that's why I mentioned it.
Okay, that's what I was kind of going at. Mr. Jeanette? Oh, Mr. Bernhardt. Go ahead with your presentation.
All right, so there's one violation for Code Section 3-1804C. Billboard signs are prohibited style of sign and shall not be allowed to be erected anywhere within the city limits of Clearwater. Which is just a little definition. A billboard sign is an off-premise sign that exceeds 24 square feet. The notice of violation was mailed in June 9, 25, compliance date July 9, 25, and certified mail came back in June 26, 25. So that case goes a little bit back. I did a routine inspection of the sign. Actually, it was before the hurricanes in September 14 of last year, 24. And there was some concerns about maintenance issues with the sign. So the structure showed deterioration. You can see wood rot, what we call the catwalk upon the sign was deteriorated, also showing wood rot. And there's a ladder on that side, a metal ladder that was warped and rusty. So it was just concerns that the sign was not safe anymore. And as you see, the poles show wood rot and deterioration. And you can see that the sign basically it's at the end of its life cycle already. So these pictures are taken after the hurricanes in October 2021, 24. And you can see from here the ladder is warped and the whole structure is in need of maintenance and basically and not in good shape anymore. Here's another picture. And so after the storm, the entire structure tilted 5 degrees southwards, as you can see. So that pole here is from where the electric is. There's the meter attached, and you can see how far the sign is tilted already. No, it's stuck. All right, okay. And I noticed in January 25, there's a work crew working on the sign. There is here a large crane, you can see, There's a little excavator, a truck with cement bags, and they were working on the sign. There's no permit for this type of work. So I started a stop work order at this point. And give me 1 second. Takes a very long presentation. Computer is slow. So they didn't change anything of the structure. They made the sign plumb, so it's just stabilizing the sign. But again, that type of work would need a permit. Let's see here. Again, and it was after the annexation agreement asked for demolishing the sign. It was already past that date. This was done in June 9, 25. The picture, again, it's again used for advertising. You can see a face panel there. And that was yesterday, August 26. So the sign is still present at the location, or 8 months after it should be demolished already. All right. Pictures. Again, it's still the same situation, shows deterioration. And all right, compliance can be met by removing the sign and the sign structure by the compliance date. Recommendation for the case 7925, requesting compliance on or before September 27th, 25. If the violation continues to exist, impose a fine of $250 per day. Each day the violation continues to exist. Any questions for the board?
And board, do we have any questions for Mr. Berger? No.
You do not?
Mr. Chinley?
Yes, sir.
Would you like to approach the podium? I don't really know what I'm going to ask you, but because you already admitted to the violation of it.
Yeah, there's just a little backdrop to this situation here. First of all, we were considering naming the sign as a historic sign because it's been there for 58 years. But the sign's actually coming down. We had a contract to sell the property with a closing date in 22. And as you remember, the Fed started fooling around with the interest rates in 22, and a lot of developers, including the one that we had under contract, backed away. And so in order to develop the property, there's actually 4 parcels on this particular property. 2 of them are in the city and 2 are in the county. And so in order to develop, you got to annex into the city. So even though it was a voluntary annexation agreement to eliminate the billboards, the city wouldn't take the property unless I agreed to remove the billboards. So we did that, and you saw the annexation agreement. Since that time, the developer backed away. We have a development order in place for 270 units. We are very soon going to submit another application for a new developer for 354 units, of which the billboard sign's coming down regardless of this hearing. What I'm asking is, and the city's been very gracious in allowing us to keep the billboard through this time, not denying that at all. There are contracts in place with I don't own the billboard, I own the property and lease it to a billboard company. They were upset about sunsetting the billboard without any compensation, and they were considering a lawsuit against the city to go after some compensation under eminent domain. They decided not to do that. They have agreed to take the billboard sign down. What I'm asking for is some additional time to let the contracts expire that are with the vendors on the billboard sign and with me. So the sign's coming down. If we were not here and all this were not taking place, the sign would come down anyway with a new development, with a new site plan. And the site plan that was submitted to the city through the development order it wound up without having a billboard sign on it. So I'm just asking we're going to take it down. I'd like to get some extended time beyond the September's as the city's requesting. So it can be a smooth transition, so the contracts that are in place with the advertisers and the sign owner and me expire.
What kind of time do you think you're looking at?
That was actually the 15th of January, but they've cut that to if we could get by December 31st.
That's a lot of time.
Well, you know, in answer to that question, the sign's been there for 60-something years. I believe the city has had no complaints from any citizens.
But it did have a finish date of January of this year. That was the finish date for it specified, right? That was in the agreement.
Right, and the reason the city gave me some extra time is because we were hoping that a new developer would come onto the picture sooner, but fortunately, the economy wasn't the right for these kind of developments. Trump was elected. You see, you know, things improving. My phone is ringing off the hook. There are developers interested in that property and for multifamily use.
It's 90 more days.
It's actually not that much when you think about that.
Board, what's your thoughts on this, guys? Strickland?
Chair, I think the city would like to speak on the issue.
Yes. Mr. Simpson, come forward, please.
Sure. I just did want to make a couple of comments on the, I did provide an additional document that you may have in your packet that is the State Department of Revenue's life expectancy of an asset, and billboards are listed in there, and they're 20-year life expectancy. So
60.
I appreciate the testimony regarding the length of time that it's been there, but I think that that's actually evidence that it's far beyond its life expectancy in terms of an asset. With regard to the billboard's attorney, I did notify the billboard's attorney about the hearing today, and they made no indication to me whatsoever that they plan to attend or participate in any way. They did contact my office and request more information. We provided them the annexation agreement, and then we did not hear anything else from them at all. So there's been no notification to the city that there's been any kind of anticipated litigation. So I just wanted to add those things to your context.
I can add to that. I talked them out of moving forward because they would have sued me and the city as well, and there's no reason for that.
We don't want anyone to get sued. I mean, you know, we do understand though that there's a contract with them, and that's what they're going to be losing out on. Is if you have to bring it down by the city, they're going to lose out. You know, the money they paid, and somebody's going to have to pay that back. Board, what's your thoughts on this, Mr. Kinney?
I have a question.
Yeah.
Did the billboard company know that you signed a contract saying the sign would be down as of January?
Yes, but they had contracts already in place with the advertiser and with me.
Okay, but you signed it anyway, knowing that they had contracts, that it would come down, but knowing that it wouldn't?
They had a contract with me, but I didn't know about, it's not my business to know about their vendor contracts. You know, with the billboard, they pay me rent.
I understand. Okay, but I guess my question is, did they get contracts after you told them the sign was coming down January 1st?
I can't answer that for sure, but I think they did not, because they knew that the billboard sign was, according to they had the development order. They were seriously considering suing. They hired an attorney to look into it. And I was not happy with that, and so we talked about it, and I said, there's no reason to sue the city. The city has been nice. They've extended this. There's no reason to sue it. Billboard sign's coming down anyway, regardless of whether we were here or not.
Thank you.
So your arrangement is with the owner of the billboard because you don't own it, correct?
That's correct. We lease the property to the billboard company.
All right, and so they have an independent arrangement with whoever they whoever puts up a banner and advertises, is that correct? And you're not involved in that?
No, I'm not involved in the management of that billboard sign.
Okay, did you notify the the billboard, the sign owner
Yes.
of this agreement that it was coming down?
They know all about the hearing, the agreement, they know everything.
Okay, so they knew that there was this annexation agreement provided for the sign coming down
Yes,
as of last January?
January of this year.
Right. Okay.
Yes.
Good. So
And the city's been cooperative in not pushing this.
Right.
And, I'm asking just for a little bit more time. It's not, I know it's 90 days, but there's contracts in place, and it would be a smoother transition if we could just extend it.
How long ago was the contract with the billboard company executed?
It's 30 years past its.
Let's see. Well, I'm not trying to be facetious.
A long time ago?
Years ago. My dad.
Okay. And there wasn't any provision in there for
The fine starts.
your, transfer of the property or any governmental regulations or whatever?
Leases go with the property.
Chair, we have to record this, so please no cross-talking while someone else is. I'm sorry.
Yeah, agreements go with the property, not with the individual.
it would seem to me the smoothest, easiest thing for us and Mr. Janelli would be to give him until the end of December, then it's gutted, and then give him like 15 days to get it down.
That's what.
That allows his to remain in place, and granted, it's the only downside of that is the amount of time allowed, but from my perspective, that's the smoothest thing to do.
For January 15th.
And if you guys want to do something different.
I don't have a problem with that.
I agree.
So put a
Okay.
January 15th date on it, something like that, so he's
Yeah,
got 15
down by
days.
the 15th, January.
That was my suggestion, is January 15th. If you want to go to the 11th, that's my birthday.
Okay.
Somebody make a motion. I mean, I haven't. Is everybody? Yes.
Sorry, you're here a lot for me today, so it's okay. The agreement that was adopted and recorded into the public records and went through the hearing process, that was all approved by council. So that deadline is, we're beyond that deadline. If the board kind of delays, I guess, just hearing the conversation, if what is being talked about, if that's what is approved, it wouldn't really affect the city's ability to try to enforce the remedies of that agreement through some other legal process. So I did want to be clear about that so that there's not a misunderstanding between all the parties here. The agreement's clear, the deadline in the agreement's clear. The agreement says that we can seek relief to remove the billboard and that sort of thing. You've heard the evidence. It's well beyond its life expectancy as an asset. It's well beyond the deadline in terms of what was already agreed to in the annexation agreement. In terms of whether or not ad buyers have contracts with the tenant or these other things, we haven't really seen any paperwork to support any of that in terms of what this extended deadline should be. I mean, we'd like to see that if we're deferring to that. I understand if we don't have that today, that is what it is. But we're beyond the deadlines of all the recorded documentation for that. So just want to say that. I guess if the deadline is extended out, the city would probably be exploring other avenues to get compliance.
So Chair, basically you're being told that no matter what you do, it doesn't matter.
That's right.
It's coming down. Plot thickens.
Yeah. Rebecca Mulder, Code Manager. I just to add to clarification, what we're presenting to you is a case whether or not this billboard is in violation of our code, that it's a prohibited sign, and then if you find it in violation, you can associate fines potentially or not, however you seem fit. But what we're presenting on is if it is a violation or is not a violation, and whether or not you want to associate fines with that. And then the annexation would be something separate that legal would work with the property owner to resolve.
Thank you.
Well, the board's already determined
we
there's a
found it's a
violation.
violation.
So now the question I think the board is asking from the city is what time period? We've already heard from the request through January. So I think the board wants to hear what the city wants to say regarding the time period. Or proposal may be that we ask for an update in 60 days, because if something falls through with this agreement, the board may just want to have this removed from their perspective. I mean, obviously, the city can do whatever they want.
I don't think that we can agree to a specific date unless we can see some documentation of what Mr. Janelli is talking about. Otherwise, we have an agreement that we all agreed to in terms of what the deadline was.
I'm sorry.
This mic's not on, I'm sorry.
I'm sorry.
I'm sorry, I was hoping I could.
You don't have to repeat
not,
it.
interfere with his space here, but that we have a deadline and agreement that was already agreed upon, that we're past. So if we're talking about extending that agreement, that's something that our position is the city council would need to amend that agreement through the city council process. Now, if the board wants to delay the imposition of a fine under the board's authority, because the board has the authority to do that, we acknowledge that, of course. If that's what the board is inclined to do, then it doesn't override the terms of the agreement, I guess is what I'm saying. The agreement is still clear that there's a deadline in place.
And I think the board knows that. I think the question becomes, what are you really, I mean, the violation has already been determined by the board. It was admitted to.
And admitted to, yes.
So the question really becomes, what do people want the board to do? Because you could do, the city obviously, if the board said, hypothetically, we'll give you 5 years, the city can come in and do whatever they want. If you want a short period of time, and because the board has to give a reasonable time period to come in compliance. That can be 10 days.
Mm-hmm.
I mean, so it's kind of, what do you all want to do? Otherwise, let's just assume you do 10 days and they don't do it until January, then you have a fine running. I mean, that's, if the idea here is to get compliance.
Right.
So I'm trying to figure out what's the best way for you all to make that determination.
I mean, we could determine whatever we determine today, and the city could come in tomorrow or Friday and be out there with bulldozers or
Right.
whatever they are to tear it down.
Right, they have an agreement.
Yeah, they
and
already
it's been
have an
violated,
agreement that
so.
that has nothing to do with us. We're just trying to find out if he's in violation, and we already did find
Right,
it out.
so you have violations, so then I would say the board just needs to determine a compliance date and a fine if failure to come in compliance.
What is the amount of the fine that the city is requesting?
$250 a day.
$250 a day.
And just to
So-
clarify, the contract was signed by you, Dr. Janelli,
Yes.
correct? And it was not contingent upon your tenant's agreement?
Correct.
Okay. I just
Yeah.
wanted to make sure.
I'm not denying the violation.
Yeah.
We signed the agreement. The city's asking for 30 days. I'm asking for a little longer time, which the board has granted on a number of occasions in the past for whatever violation.
But there may not have been a contract. I think that we have to stick to what the city wants, because otherwise they can come in and do whatever they want, no matter what we say anyway.
Well,
Correct?
I don't,
Is that correct?
in order, well, there would be a process for the city to do that.
Yes, yes.
Yeah.
And that's not going to
They've already-
happen. They're not going to come in like,
Friday.
Can I,
like Putin would do and knock us down, you know. They-
Rebecca Mulder, Code Compliance.
Regardless of what we say up here, their January 1st, 2025 ruling still stands.
Absolutely.
you know?
I'm not arguing
So,
that point
yeah,
at all.
no, I mean,
I'm
So-
trying to get some empathy from the board to extend it a few more months.
Trying to find a way to give you.
Yeah,
some-
no, I get it. I understand. Mr. Brown, I understand exactly what you're going through.
Is there
Board,
any
can I
chance that
say
this,
something really quick?
Property would change hands by December 31st,
Change hands,
like be sold?
that's a possibility.
Okay. And also, what's the rent income per month for the billboard?
What's the rent income? I'd have to go back and look at my notes. It's significant.
Board, I just wanted to clarify again that, because there's still some discussion, the annexation was a document that we presented to you to give context to why the property is now being called to be a violation and was not done so prior. As we presented and as Dr. Janelli has stated, this billboard has been around a while, was a pre-existing non-conforming billboard due to that annexation agreement, and is now outside of that, and we've been working with him to try to get it into compliance since January. It's now August, and so at that point we brought it before the board. The annexation is not something that we're looking for a determination from you, but rather whether you want to impose fines on what you have found in violation, how much, and how long they have before those are imposed due to whether or not the billboard stays or not. So I know there's a little extra to this case, so to go back and forth, I just want to provide that clarification or restatement of what we're looking for from you as the board. The city does have the ability to seek legal measures. We're certainly not going to be going out tomorrow with, I have no plans as far as I'm aware to go out there with a billboard or a bulldozer for the billboard, but that was based on the legal agreement. We do have that right to enter the property, but that's not what we're seeking today.
And I would be happy to update the city in 60 days and give them what, maybe the time frame can be shortened, don't know.
Board, anything else? Any other input?
Suggestion, 30 days.
That's, I mean, yeah, that's fine with me. Whatever's fine with me, really. I mean, you guys, somebody make a motion?
September 27th.
It would seem to me that in a position like that it's not down, I mean, the city obviously made an agreement, Mr. Janelli made the agreement. Circumstances outside of that, or circumstances outside of that, I mean, this puts it into compliance. It leaves the door open for the city to do something else if they want to do something else, but it kind of holds the agreement in place and honors the original agreement. And at the end of the day, if development is done or whatever, the fines get handled, but, it applies, it follows the city's agreement.
We'll go with that.
Make the motion.
Let me, I'm not so sure that actually, if we started today, it could come down in 30 days. I believe they may need a permit to demo it from the city. I don't know the process, but I'm not so sure it could actually physically come down within 30 days.
You would need a permit for that.
How long, any idea?
It's a demo, I would assume it's just a signed demo permit from the contractor's perspective, but
How long would it take, any idea?
that's probably better addressed to a sign company. But the other factor is this thing has been in place for a while. I mean, that could have been done and be sitting there in terms of a permit, but just not executed yet. And so I wouldn't consider that a mitigating factor from my perspective.
Okay.
Couldn't they come back and ask for more time and show us what progress they've made at that point?
Normally what we would recommend is they just deal with the city directly on that.
Yeah.
With the motion.
We ready? All right.
Make a motion.
I move to enter an order requiring the respondent to correct the violations on or before September 27th. If the respondent does not comply by that date, the board may order a fine of $250 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second that.
All in favor?
Aye.
All opposed? Motion approved. Thank you, Dr. Janelli. Board, we're going to take a 5-minute recess for right now. So we will reconvene in 5 minutes.
Take a breather, huh?
All right, come to order. Let's bring the...
Hold on 1 second, Chair.
Nicole has superseded you.
Call the Code Enforcement Board back to order. Next case is 4.12 on our docket, case 88-25, J.S. Perry and Company in violation of code for illicit discharge at 839 Bay Esplanade, and issue an order that specifies a fine and irreversible violation and includes administrative costs and establishes a date payable. Is there anyone here to speak on that case?
Thank you, Mr. Chair. Jared Simpson, City Attorney, Assistant City Attorney for the Code Enforcement Team, and I am here again. This is, I'm here because this is a case that the board has not seen, a case type that you've not seen, but we are anticipating to bring more of these. An illicit discharge, we do have staff here can kind of explain a little bit more what that means, but essentially it's when someone puts something into our stormwater system that is not stormwater. So only stormwater is allowed to go in the stormwater system. Anything that's not stormwater is technically a violation if the city can prove that they are the person that did it. For this particular one, we negotiated a stipulation agreement with the attorney that represented the contractors. So actually, we're just asking you to approve of that stipulation. One of the things is they didn't want to miss work and pay an attorney and have all the expenses of coming to a hearing, so they wanted to waive their coming to a hearing, and in exchange for that, we agreed to a specific fine amount and that there be a finding. You can see that all the terms of the agreement. That is something that the parties, myself and an attorney for the contractor, negotiated that agreement. So we're essentially just asking you to adopt that. I do have some staff here for Public Works, and I thought it would be helpful for you to meet them, and if you'd like to hear a little bit more, I guess maybe after this particular case or later in the day, however you all want to do it, staff are here to explain the illicit discharge program a little bit more if you like, or we can schedule that for another day in the future, however you like to handle it.
Another day.
I appreciate they're here. I would request another day in the future because the meeting has gone as long as it has, and we still have some agenda to exercise. No offense to them. I don't know what everybody else thinks.
I'm good with that.
Okay.
Yes.
We would like to thank them for coming today, please.
You want to just come down and introduce? I'll just have him just introduce himself, if I may. This is our deputy city engineer. Just so you can see the staff that are working hard on this, and this is an important program. I just want to say before I give up the mic that we've been working hard on this for a while, and it's very important, part of the National Pollution Discharge Elimination System Clearwater Act program, very important environmental initiative of the city that we've been working hard on, and we're finally rolling with it. And so with that, I'll just introduce the folks that are out there making it happen.
Thank you. My name is Jeremy Brown. I'm the Deputy City Engineer here for the Public Works Department. This is Jarvis Sheeler. He's our Environmental Code Enforcement Inspector who goes out. He's all of our eyes and ears out there. Happy to come back and explain a little bit more about the program. Thanks for having me today.
We'll get you another afternoon out of the office here next month. I appreciate you guys for coming.
Thank you.
Okay, so on this J.S. Perry Company, we just need to go through the violation, and is that where we're at?
Well, I'll defer to your attorney on what would be appropriate. What the city's requesting is that you approve of this agreement, and essentially it finds that there was an illicit discharge that occurred. That violation is irreparable in nature because once it's out into the ocean, it can't be put back. And so we're asking for a specific fine amount. I don't recall the exact number, but it's in the agreement. I believe it's $1,500. You just confirm that.
I don't think we have it.
I don't have the agreement.
I guess we could just say that.
There was a stipulated order between J.S. Perry.
No.
Jared, you're right.
Do you have it?
No, well, yeah.
So we still do the first
You have
violation.
We may have called it a consent order or a stipulated order instead of an agreement. My apologies.
You can do the first motion.
Okay. I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Have a second?
Point of order. Is that, we have a copy of something we've never seen. It's not this?
That's not it.
Not yet.
We're not dealing with that.
Well, this is the irreparable, it actually.
It has something to do with it, but it's not yet.
Okay.
We probably
Okay.
should have done them reverse order.
We've not done it before, I'm just trying to get a footing here.
Now, a second, please.
Second.
All in favor? Aye. All opposed? Motion
We're just trying
carries.
to determine the amount, because you'll see when we talk about the next situation, irreparable harm allows for a flat fee.
Thank you.
It is $1,500, so we're asking for a $1,500 fine because it's irreparable damage based on the discharge.
$1,500.
My apologies.
I moved
I
to-
did have it in,
Is that correct amount?
Is the 30, September 27th, is that the deadline date?
To pay?
Yeah, 30 days.
I believe the order does stipulate a time to pay.
Yeah.
30
Because they
days.
can't correct, but if they don't pay within a certain time, we would take the order and record it. to
30
make it
days
a
from
legal-
our order today?
I believe that's what it says.
Okay.
Did you pull it
I'm
up?
sorry, yeah, what was the question?
30 days from our
Yes.
order
Time to
today?
pay.
Yes.
Okay. Yep.
And that, and board, that's what this extra motion that you have in your packet is for.
Okay.
So you could use that even though you haven't adopted it.
All right.
I moved to enter recorder of responding respondent to pay in the amount of $1,500 of fines to be paid 3 months after such lien is filed. The city is authorized.
1 month, 30 days.
30, well, it says 3 months. 30 days after such lien is filed, the city is authorized to foreclose, collect, and settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. All right. Now we'll get to old business items. We're going to accept the affidavits of compliances of cases 5.1.1, 5.1.2, 5.1.3, 5.1.4, 5.1.5, 5.1.6, 5.1.7, 5.1.8, 5.1.9.
I move to accept the affidavits of compliance as listed.
Second?
All in favor?
Aye.
All opposed? Motion carries. Now, to nuisance abatement filings, 7.1.
Other business.
6.1.
Oh, wait, I'm sorry. Oh. 6.1, review changes to rules and regulations, Article 4, order of business, and Article 9, enforcement.
So you have before you the irreparable harm, and you've already experienced what is being asked, and that'll be brought to you. This is a very significant issues that'll be brought forward. Just so you know, there's been very expensive litigation under the Clean Water Act, not necessarily for Clearwater, but for other cities in the county, and I've actually litigated part of this. So it is extremely expensive. It causes problems with the state, and then private individuals come forward and they mimic the state, and they get a lot of attorney's fees for doing these things, if the city is found to have violated it or done anything. So these are very clear irreparable harm type cases. The city has said that they're going to be bringing these forward, so we wanted you to have the motion available and any questions on those motions. As we said, the difference in this case is if you find irreparable harm, you can put a flat fine versus situations where you get people to come in compliance. As was mentioned, you can't come in compliance once you've done, right. This is a violation that, and we've never really, I can't think we've ever had any irreparable harm cases brought to you. So this will be something new. And so we wanted you to look at this, make sure you're comfortable with it. If there were any questions, we could answer.
A lot of those questions will be answered by our two gentlemen that were here earlier, correct?
They're going to give you kind of the background of what I just said to you, because, I mean, we could go into detail, but these are very highly expensive litigated cases. They have special, and I'm joking because there's counsel out of California that brings these cases forward, and there's counsel out of California that defends them. And they go around the country and do these cases, and the losers in those cases are the municipalities that have to deal with that, especially in light of the fact that the municipality has to deal with the state too. So normally those cases are resolved with the state, and then we get civil cases filed. So these are important for the city to have these and have the people that are responsible be held responsible. Did you all want to add something?
I would just say that in terms of the irreparable, when we bring a case to you, we're asked for an irreparable fine, we will present to you evidence of the fact that it can't be corrected. Some of this stuff maybe could, if say, for example, a concrete person is dumping, washing out their concrete into the drain, maybe they could, if we don't have evidence that it made it to the ocean, they may be able to vac truck out that drain and clean out the drain and hire a contractor to clean out the drain, all with the permission of the city. We would probably want to get restitution for any expenses or anything like that. But in terms of whether or not it's irreparable and therefore qualifies for the flat fine, we will present evidence to that effect and as part of our request to that. And it can go up to $15,000, which we would also explain our justification for why we're asking whatever.
You'll recommend the fine also?
Yes.
Okay.
You cap it at 15, you said?
The state law caps our fineability at $15,000 per violation. So our code adopts the limits of state law.
All right. Does anyone else have any questions on these rules and regulations that we can answer? Or if not, we'll just wait till our city engineers come back and...
That was the deputy city engineer that you just met,
Yes.
and our environmental staff that works with public works, and we see this all the time, and like everything that we enforce, we try education, voluntary compliance, we go through all those things to try to work with people before they end up here. So I'm not saying you're going to see a huge amount of these, but now that we have a protocol in place, and we've had our first case, you might start to see more of them.
Okay.
And we'll attach this to your notebook.
All right.
Or ask you to attach it to your notebook, depending on how.
I put mine in the back in the sleeve just so it doesn't get lost.
There you go.
So I don't get to read them off anymore since
No.
I'm sitting here, but, you know.
Could I ask one question?
Sure.
Could you give us an idea of what a typical case or what kind of things we're looking at?
The most common illicit discharge is what I just said, that washing out a concrete mixer into the street. You see paint, painters often will wash out their paint out into the street. Oil, other chemicals like that get washed out into the storm drain. Those are the most typical types of violations, and they're usually involving active construction sites. So a lot of times we do try to address these things through inspections and permitting processes before we bring someone to the board to try to get a fine.
Okay. Thank you.
So I have a quick question. If those are on public land, but if it's on private land, like in HOAs and stuff like that,
Well, the illicit discharge code is applicable to the MS4, which is the city's stormwater system. So as part of, if we're bringing those codes, we will have to show that the pollution entered into the city system, or that it entered into some pipe that connects to the city system. Most all of the pipes do, because water doesn't recognize property lines. It just goes wherever the gravity takes it, and eventually it goes through the city's system at some point. But that would be a key element in our case, would be proving that it entered into the city system, because that's what triggers the violation.
Good. Any more questions?
No, thank you.
All right. And the gentlemen that were here that we met, they will be back to educate us a little more on this. Or-
This case,
Well, I mean, not on this case, but on this in general.
yes, those will be the staff. Those are the staff members that are leading these efforts at getting compliance. So when we do have these cases, those will be the gentlemen that you'll see. They'll explain all of this details that I just
Instead of the
described.
inspectors coming up, it'll be them guys that come.
Right, they'll be handling those cases.
Okay, sounds good. All right, any other questions about the irreparable harm?
Nope.
All right, now let's move on to nuisance abatement lien filings. 7.1 on our agenda, case number 100-25, accept the nuisance abatement lien for respondents JJJ Family LLLP at 2171 Belcher Road for lot clearing and issue an order with compliance deadline to authorize the city to mitigate the violation if compliance is not met. Inspector Casman, you have the floor.
All righty. Good afternoon, Board. Daniel Casman, Code Enforcement Inspector for the City of Clearwater. Might have swapped these accidentally. This is supposed to be case number 100-25 for 2171 Beecher Road, the nuisance abatement. One violation. Sorry.
No.
You confused me.
That was my bad. There's one violation here for code section 3-1503 B5A, B7, B10 for lot clearing. It's the date and notice violation went out with the compliance date and the affidavit of posting. This is 2171 Beecher Road. This came in as a complaint about the unfinished building, but also the lawn. Next to the building, there's piles of trash and debris from the construction. There's a tree on the side of the house, which is overgrowing the sidewalk, making it difficult to use, and the rear yard is unkempt, though the front yard tends to be cut. They're not cutting the rear yard. This is the date of the posting. The property was in the same state. This was after the compliance date, same state, and this was this morning, same state. So compliance met for lot clearing by mowing the lawn, cutting back the tree abutting the right-of-way, and removing all trash and debris from the premises. I'm requesting compliance on every 4 or 5 days from the date the board renders its order.
Any questions?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with the reasonable cost which will become a lien on the property. If the costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or set to settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. Okay, 7.2 on our agenda, case 101-25, accept the nuisance abatement lien of respondents Thomas C. Little at 1931 Ashland Drive for lot clearing an inoperable vehicle, and issue an order with the compliance deadline and authorize the city to mitigate the violation if compliance is not met.
Good afternoon again, board. Daniel Kasdan, Code Enforcement Inspector for the City of Clearwater. This is case number 101-25 for 1931 Ashland Drive nuisance abatement. There's only now one violation here. They did cut the grass, but for code section 3-1503B6, the vehicle on the premises still does not have a current tag. This is the date notice of violation was sent out with the compliance date and the affidavit of posting. This is 1931 Ashland Drive. This came in as a complaint for the yard. When I walked up to the home, I noticed that the trailer had an expired tag. I'm sorry, that's hard to see, but it's February 20 of 2025. So this was in August, so we're already 6 months past. This is the date of the posting at the property. The grass was still high. This is after the compliance date. The grass was still not cut. The trailer was still had an expired tag. Went by the day, the grass had been cut, but the trailer's tag is still expired. So compliance may have for the inoperable vehicle by displaying a license plate with current tag on the hauling trailer or by removing the vehicle from the premises. And I'm requesting compliance on it before 5 days from the date the board renders its order.
Any questions?
You want to do it?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violation within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with reasonable costs, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
I'll second that.
All in favor?
Aye.
All opposed? Motion carries.
Thank you very much, board.
Thank you.
Thank you. Next on our agenda is 7.3, case number 102-25, accept the nuisance abatement lien for respondents Nathaniel Robinson and Ernest Bell at 1730 Harvard Drive for inoperable vehicle, and issue an order with compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Dixon, you have the floor.
Good afternoon, Board. Inspector Dixon, Code Compliance Inspector, City of Clearwater. This is case 10225 for 1730 Harbor Drive. One violation at this property for inoperable vehicles. Notice of violation was posted and mailed at the end of July. Compliance date at the beginning of this month.
It says Macomber.
Say again?
The address on that says Macomber?
Oh, that's a typo.
Oh, okay.
This is 1730 Harbor Drive.
Okay.
There's 4 or 5 vehicles over on the left side of the picture there. They all have expired tags or they're inoperable. From the sidewalk, it's a little hard to tell, but when you're in person, these tags are expired. I have talked to the owner. 2 of these vehicles belong to somebody that doesn't live there. They're just being stubborn, not removing them. He says that the truck on the left and the white car are going to get repaired. We'll see. There's no fuel tank in there. It's up on a jack stand. I believe this is today. I don't know why this picture's blown up like this, but none of the vehicles are removed. He says they'll be done in the next couple weeks, but we'll see. This car did get a new tag on it, still has no gas tank though. So compliance will be met by ensuring all vehicles are roadworthy, have inflated tires, and display a current registration sticker on the license plate assigned to the vehicle. Request compliance in 5 days.
Any questions, board?
I move to enter order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property. If cost, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carried. 7.4 on our agenda, case 103-25, accept the nuisance abatement lien respondents Edna Peacock Estates at 1822 Carlos Avenue for lot clearing and issue an order with compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Dixon, you have the floor.
Case 103-25 for 1822 Carlos Avenue. It's one violation for lot clearing, accumulation of trash and debris. Property is posted at the end of July with a compliance date at the beginning of this month. It's a vacant home. Neighbors tell me that the individual who lived there passed away. I haven't been able to get a hold of anybody. Nobody's contacted me. The front yard looks a little less overgrown than the back because the neighbors were mowing it. So I told them to stop so that I could write it up. This is all the day of posting. And then these are pictures from yesterday. Compliance can be met by clearing all overgrowth from the property and removing all debris. Request compliance 5 days after the board renders its order.
Any questions?
Nope. I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion approved. Next case is 7.5 on our agenda, case 104-25, accept the nuisance abatement lien for respondents Ann S. Collins Estates at 1877 Springtime Avenue for lot clearing an inoperative vehicle and issue an order with the compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Dixon?
Case 104-25 for 1877 Springtime Avenue. This is the property that I presented at the top of the agenda. The nuisance cases. There's 2 violations here for lot clearing and inoperable vehicles. Notice the violation was posted at the beginning of June. The case kind of got away from me, so I reposted it in July, and we're here today.
Yep. All that earlier.
The front yard is overgrown on the day of posting. There's a vehicle in the driveway with an expired tag. The rear of the property is overgrown. There's no tag on this vehicle. As of today, the same plate is on the vehicle. The front yard's been mowed, but the backyard's not been mowed, and the white car is still there. So compliance will be met for lot clearing by clearing all overgrowth from the property, removing all trash and debris. Compliance for the inoperable vehicles by removing all inoperable vehicles from the property or ensuring all vehicles are roadworthy, have inflated tires, and display current license plate and registration. Request compliance 5 days after the board renders its order.
I move to enter order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second. All in favor?
Aye.
All opposed? Motion carries. 7.6 on our agenda, case 105-25, accept the nuisance abatement lien for respondents Burfkin, Akayan, and Yüksel Durman at 1803 Apache Trail for lot clearing and issue an order with compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Dixon?
Case 105-25 for 1803 Apache Trail. One violation here for lot clearing and accumulation of trash and debris. Notice the violation was posted and mailed mid-month for the compliance dates of over the weekend. This house has a demo permit. The cut and cap's been completed, but the permit for the demo is under revision. It's overgrown. And today it's still overgrown. So compliance can be met by clearing all overgrowth from the property, removing all debris, and request compliance 5 days after the board renders its order.
Any questions?
No. Anybody want to take it?
Somebody else take a turn.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such a lien.
Second.
All in favor?
Aye.
All opposed? All right, motion carries. 7.7, 7.8, 7.9 have been withdrawn.
If you don't mind, maybe we go out of order
I
a
was
little
gonna
bit.
say, I see
so
that
can
up
do
there.
my 7.13.
We will skip to 7.13, case number 112-25, accept the nuisance abatement lien for respondents Joyce Green at 1341 Fairmont Street for inoperative vehicle and issue an order with compliance deadline, authorize the city to mitigate the violence if compliance is not met. Inspector Dixon?
Case 112-25 for 1341 Fairmont Street. There's one violation for inoperable vehicles on the property. This vehicle was posted at the end of last month with a compliance date on 8/11. Copy of my posting. There's a vehicle in the driveway that had no tag. This Kia has a tag that expired in 2023. And I suspect that these two vehicles are in-op, but I couldn't trespass onto the property to see behind them. This is this vehicle yesterday. It still has the expired tag. These two vehicles are still on the property. This vehicle does have a tag. They put it in the window and it expires in 2026, so I still have a couple vehicles I need to deal with. Compliance will be met for the inoperable vehicles by ensuring all vehicles are roadworthy, have inflated tires, and display a current registration sticker on the license plate assigned to the vehicle. And I would request compliance 5 days after the board renders its order.
Mr. Plum?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid, 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All opposed? Motion carries. Now back to 7.10 on our agenda, case number 109-25, accept the nuisance abatement lien for respondents Constantino Pantazes and Dionisia Revocable Trust and at 331 Harbor Passage for lot clearing and issue an order with the compliance deadline and authorize the city to mitigate the violation if compliance is not met.
Good afternoon, Kevin Maddox, Code Compliance Inspector. Case number 10925. Number of violations, one for 1503B7 and B8, overgrowth in the right-of-way. 8/11, it was posted violation, compliance date for the 21st of August. Green card was not received, but it was posted. The first picture is our house showing posted with photography showing long grass. As you go around the property, the grass continues to be long. It's posted here where it's readable. This was on the 21st. It's is not showing it very well, but 21st, it continued to remain the same in all angles. On today's date, this morning, I went out and it again still appears to be the same in all angles. Compliance can be met for lot clearing by cutting all grass and vegetation to include the curb line sidewalk and continuing to maintain it. Of these violations, requesting compliance 5 days after the board renders its order.
Any questions? Mr. Strickland?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with the reasonable cost, which will become a lien on the property. If cost, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second. All in favor?
Aye.
All opposed? Motion carries. And now to 7.14 on our agenda, case number 113-25, accept the nuisance abatement lien for respondents Maria and George Ackerman at 832 Narcissus Avenue for lot clearing and issue an order with the compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Maddox?
Kevin Maddox again, case number 11325, 832 Narcissus Avenue. I can't say that word either. The T continues to add. Number of violations, one violation, code section 1503B7, 8, and B58, lot clearing, overgrowth, and right-of-way accumulation of debris and trash. Notice the violation was mailed and posted on 8/12 of 2025, compliance date of 8/22/2025 with the certified mail green card not received, but it was posted. First picture is the front of the property showing the long grass and overgrowth and right-of-way into the sidewalks. This was on 8/12 of 2025. Here it was posted. Again, this was on the 22nd of 2025. It had just rained, adding water to the already long grass. And it was still just getting longer. And then this morning, it appears that the grass was a little bit longer and quite overgrown into the sidewalk. Compliance can be met by cutting all grass vegetation to include the curb line sidewalk and continuing to maintain it, removing all trash and debris and continuing to maintain it. Of these violations, we're requesting compliance 5 days after the board renders its order.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with reasonable costs which become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second. All in favor?
Aye.
All opposed? Motion carries. And if we have no more business to attend to, the board will be adjourned.
Thank you.
Marathon.